has an industrial scale model that they have been doing this for more than 10 years. They advertise and they run articles in the People's Daily, the CCP main publication, telling members of the Chinese Communist Party elite, go to the United States, your child can get U.S. citizenship. They're encouraging them to do it. And we in the United States have no idea how many Chinese officials have done this because we don't track it. It's not on birth certificates. The Chinese government believes that over the last 13 years, every year, roughly 100,000 Chinese babies have been born in the United States who are then brought back to China where they are being raised.
I want to go over to the Andrew Breaker show, right? And to Andrew Breaker show. So this guy, I like to follow a lot, right? And it's for the reasons that he gives a legal analysis with regards to the whole aspects of birthright citizenship. Because he most definitely feels that American has been invaded. And I've been looking for a more short version to give to you with regards to his analysis because I am one who likes to myself understand law. I have fought cases myself. I am not an attorney, so I would prefer that you actually listen to an actual attorney with regards to this stuff, right? Because I am not an attorney. I am more of a per se litigant who likes to fight his own cases when it comes to fighting civil matters in the court systems. So, what I would like to do is because I don't believe that people really seriously understand the impact that the ruling in the Supreme Court would have with regards to birthright citizenship because one thing is for sure that it's a bigger argument. And I believe that more people are going to be impacted with regards to the ruling from the Supreme Court because the argument is just like I said, it's a bigger argument when it comes to the security of the nation. So all these individuals, I believe, who've come across the border for the last for a long time, maybe not actual citizens after this Supreme Court ruling. And it's for the reasons that you will find in this show today that you will definitely understand why.
On the first day of his second term as President of the United States, Donald Trump issued Executive Order number 14160, protecting the meaning and value of American citizenship. The executive order requires federal agencies on a prospective basis, so it doesn't apply retroactively, to decline to issue or to accept citizenship documents for the children of temporary visitors. That would be all visa holders. All visas are, by definition, temporary. Tourist visas, student visas, work visas, H-1Bs, H-4s for family members of H-1Bs. All visas are temporary, and illegal aliens born in the United States more than 30 days after the effective date of the executive order. Several states, individuals, advocacy groups promptly filed lawsuits across the country arguing the executive order violated the Citizenship Clause of the 14th Amendment, and courts awarded emergency relief, primarily preliminary injunctions, sometimes final judgments, preventing the order from taking effect. In the early days of those emergency proceedings, several judges voiced strong doubts that the executive order had any arguable legal basis. During an emergency hearing in Seattle, for example, one federal district judge claimed that he could not remember another case in which the government action was so blatantly unconstitutional. There was also a torrent of criticism from quote-unquote law school professors, with several competing to condemn the executive order in the harshest terms. Many insisted that there was not even a genuine debate to be had. As the cases have progressed, and by the way, I want to say again that when I saw the executive order, I was like, well, this can't be right. I thought anybody born on U.S. soil, no matter what, was an American citizen because we'd all been propagandized into believing that was the law. I believed it too. I thought, you know what, I actually better go look. And I began my research on the 14th Amendment Citizenship Clause and soon learned the truth. But it doesn't surprise me that so many judges and law school professors, the public in general, would think that birthright citizenship secured citizenship for anybody born on American soil, no matter the status of their parents. It's just not true. As the cases have progressed, however, the legal debate has assumed a more measured tone. In court proceedings, the overwrought rhetoric from the early emergency hearings was replaced with the sober acknowledgement that the government presented credible legal authorities to support its view that the qualifying language of the Citizenship Clause and subject to the jurisdiction thereof reflects requirements of parental allegiance and legal domicile in the United States and thereby excludes the children of illegal aliens and temporary visitors from automatic entitlement to citizenship by birth without the need for naturalization.
So, how far would this go back, actually, right? It's one thing that you got to consider when looking at this analysis, because this is one thing that I most definitely would have to question. And I think that everybody should question when it comes to the ruling, because one thing that is going to either have to be modified or itself overturned or re-ruled on is United States versus one Kim Art, right? Where so though at common law nationality or allegiance is the substance depending on the place of a person's birth, it is the theory at the least dependent upon the locality of a man's birth, but upon the being born within the jurisdiction and allegiance of the King of England, right? So that, first of all, one Kim Art parents were seen to have legal domicile in the country because they were not allowed to go back to China. And it is for that reason, within itself, as immigrants, that they, one Kim Ark himself, was considered to be a citizen of the United States.
Order that citizenship does not follow automatically from birth in the territory, and to the government's credit, allegiance has at least some importance to citizenship. Published opinions from the First and Ninth Circuits, these are all courts of appeal, have acknowledged that executive branch regulations from the early 20th century and at least one authoritative 1953 treatise, a legal expert writing, support the government's position. And a federal judge in New Hampshire recognized the federal government had advanced non-frivolous arguments in support of its interpretation by focusing on the concepts of allegiance and domicile. A domicile is a permanent residence. The scope of the government's regulatory jurisdiction, the status of Native Americans under the 14th Amendment. They were not granted birthright citizenship. That required a separate 1923 statute to give birthright citizenship to Native Americans. And the precedent of Elk v. Wilkins, which he's going to cover it here. In Elk, the Supreme Court held that the Citizenship Clause would confer citizenship on only those children whose parents are owing no allegiance to any foreign alien power, which required a formal renunciation of his old allegiance and an acceptance by the United States of that renunciation through such form of naturalization as may be required by law. So it's a reciprocal process. You have to renounce your old allegiance and you have to be accepted by the United States. It's a compact. It's a contractual relationship.
So you see the two aspects in which they're going into. First, you have to renounce where you where you come from, where you originated from. And upon that, you will have to, the United States itself would have to accept you. International naturalization, as required by law. So these two aspects, as we have been propaganda, propagandized, my mics, to believe that birthright citizenship deserves to be, with regards to anyone who simply set their feet on American soil and gave birth to a child in this country, child would gain citizenship. And it's important that you recognize from the beginning of this show today that what's important to recognize with regards to this is that there is a national security issue because you have places like China and who knows where else are trying to gain influence into the United States. And here we are, we're openly, through the thought of what birthright citizenship actually was, giving them the tools to do so.
The Supreme Court reiterated that view in the slaughterhouse cases when it explained that the phrase subject to the jurisdiction was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the U.S. Several commentators around the time of the 14th Amendment understood subject to the jurisdiction in a similar way. Francis Wharton, for example, recognized that Indians are held not within this clause, not being subject to the jurisdiction of the United States. The same reasoning, it may be argued, would exclude children born in the United States to foreigners here on transient residence visa holders, such children not being by the law of nations subject to the jurisdiction of the United States. Of course, they're subject to the criminal jurisdiction. If they commit a crime, they're subject to prosecution, but they're not subject to the complete and exclusive political jurisdiction of the United States. In lectures posthumously published in 1891, Supreme Court Justice Samuel Miller wrote that if a stranger or traveler passing through or temporarily residing in this country who has not himself been naturalized, so not an American citizen, and who claims to owe no allegiance to our government, has a child born here which goes out of the country with its father, such child is not a citizen of the United States because it was not subject to its political jurisdiction. Discerning the original understanding of an ancient text means wading through an enormous mass of material, evaluating the reliability of that material, and immersing oneself in the political and intellectual atmosphere of the time. Somehow placing out of mind knowledge that we have which an earlier age did not, and putting on beliefs, attitudes, philosophies, prejudices, and loyalties that are not those of today. That sort of work is often difficult to accomplish. In contentious cases argued in April and decided in June, referring here to Supreme Court schedule. As a result, academic research becomes especially important, and scholars have begun to illuminate the public understanding of the Citizenship Clause at the time the 14th Amendment was ratified. In 2018, Professor Samuel Estreicher wrote an essay suggesting the touchstone for understanding the subject to the jurisdiction of the U.S. qualification of the Citizenship Clause is whether the children born in the United States are lawfully in the country at the time of birth. And he has recently developed a full-length study concluding that the Citizenship Clause of the 14th Amendment does not confer citizenship by birth to the children of illegal aliens, and doubting that it does so to temporary visitors. He notes that the subject to the jurisdiction language of the Citizenship Clause was an affirmative version of what the Civil Rights Act of 1866 stated in the negative. Quote, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the U.S. This understanding that citizenship depended on not being subject to a foreign power was reflected in the debate over the Citizenship Clause. In introducing the language, Senator Jacob Howard said the Citizenship Clause will not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. Senator Lyman Trumbull asked, what do we mean by subject to the jurisdiction thereof of the United States? Not owing allegiance to anybody else. That's what it means. And Senator Reverdy Johnson said that all that this amendment provides is that all persons born in the United States are not subject to some foreign power. For that, no doubt, is the meaning of the committee who have brought the matter before us shall be considered as citizens of the United States. I know of no better way to give rise to citizenship than the fact of birth within the United States, born of parents who at the time were subject to the political authority of the United States. Despite what some commentators have suggested, the Supreme Court has yet to address whether the Citizenship Clause extends citizenship by birth to children of parents illegally or temporarily in the country. In United States v. Wong Kim Ark, the Supreme Court held that a child born in the U.S. to lawfully present Chinese citizens who were permanent resident aliens of the U.S. was entitled to citizenship. But Wong Kim Ark, often cited as definitive support for the extensive view of constitutional birthright citizenship, actually reflects an important limitation. The court's holding is limited to its facts. Children of parents with permanent domicile and residence in the U.S. and who had lawfully entered the country. The Supreme Court suggested that the case might have been decided differently if Wong's parents had not been legally permitted to enter and reside in the country. And decades of executive branch practice in making determinations of citizenship do not reflect the view that place of birth, irrespective of parental status, was decisive. This issue of Harvard Law Journal and Public Policy makes, so this is the Harvard Law Journal, Harvard Law Review.
Okay, I would like to draw you completely into this whole aspect of what's actually going on, right? Because what you have is you have one side, you had domestic fighting going on between white people and black people during the 1960s, which you end up having these Immigration Act of 1965. This Immigration Act of 1965 was specifically written into law and signed by Lyndon B. Johnson to die down on this domestic fighting between white people and black people, and primarily to dilute the thought of white supremacy in this country. However, it hurts both sides because when you think about white supremacy in this country and you think about immigration being introduced into this country, who are the people that are primarily going to be hurt with regards to this issue? And it's on both sides. On one side, you have the population of white America beginning to decrease since 1965 with regards to immigration. But on the other side of that, you have a lot of black jobs being taken away from from immigration as well. So jobs that black people could have been holding and could have been drawing a balance between the economic stability in this country with white people, of course. Here you are, it's bridging the gap to be that much wider. And accordingly, in most recent times, what you have is white people getting fed up about the whole issue with regards to immigration, especially after the Biden administration, which what the Biden administration did, it violated the Immigration and Nationality Act by implementing wrongfully the immigration parole system, which allowed it to say, we're going to screw the numbers from the numbers that come in across the southern border. We're going to screw those numbers. We're going to allow Cubans, Venezuelans, Haitians, Ukrainians, Armenians, and some other people to come over here. into this nation, and we're going to circumvent the southern border from allowing them to get counted at the southern border, and we're going to allow these people to come over here through ports, such as airports, such as boat ports, all this other stuff, all our ports, right? And these numbers won't be counted at the southern border, and it's making it seem like we're securing the southern border because the numbers are going down from the southern border. But we're going to allow these people to come over here as we begin to expedite them with the availability of having work visas or work authorization in this country right during the time of the pandemic. So what the Biden administration did was pretty much, it's made white people say, man, the heck with this. We need to get this in order because there is way too much immigration coming over here to this country, and this country is most certainly starting to look different from what we grew up with. Besides the fact of white supremacy, and besides the fact of trying to die down on it, hold on, we got people coming over here beginning to change the aspects of who we are. So here you got Donald Trump coming in. We're like, hold up, this birthright citizenship. We need to change these immigration laws. We need to abide by the immigration laws first and foremost. And as the Biden administration violated them, but we also need to take a look back at birthright citizenship, which first and foremost had to do with slaves.
Make significant contributions to this ongoing debate. Professor Ilan Werman helps to clarify the relationship between allegiance, domicile, and being subject to the jurisdiction of the United States. The Supreme Court itself connected those concepts in Wong Kim Ark. The Supreme Court understood the concepts in light of the common law background against which the 14th Amendment was ratified. So he's describing now, this is basically the introduction to an issue of the Harvard Law Review, and he's referring now to all the separate articles in it. Professor Werman argues that the common law rule focused on whether a child's parents were under the protection and within the allegiance of the sovereign rather than merely present in the territory. Both the allegiance to the sovereign and the sovereign's extension of protection. So again, a contract, right? A mutual relationship. For example, its consent to the presence of an alien was an essential component of birthright citizenship. Children born to parents who satisfied the common law rule were subject to the complete municipal, political jurisdiction of the United States. Quoting Professor Werman, the best reading of the historical evidence is that the Citizenship Clause extended birthright citizenship to children born of parents subject to the complete political jurisdiction of the United States. Under this framework, the children of aliens lawfully domiciled in the U.S., but not those illegally or temporarily present, would receive birthright citizenship because only lawful domiciliaries are subject to the complete political jurisdiction.
So wait, you have to just bring it in for a moment because you got to make it realize now the two prongs to this is that first of all you have to renounce where you come from, the citizenship that you have from the country that you come from. So that deletes the fact of dual citizenship, and you as well have to be accepted by the United States. One thing that you don't realize with regards to the Immigration Act of 1965 was it was supposed to be for high skilled labor jobs, and one aspect of it as well was supposed to be for family reunification, but you got a whole lot of family reunification without the aspects of high skilled labor jobs, right? Because if you would have had the uh, aspects of high skilled labor jobs, you would have been seeing a lot more white people getting affected with these jobs, right? And it's not to be racial, but it's just to be real. You would have seen a lot more white jobs being affected at the time with regards to the Immigration Act of 1965. But that's what you didn't see. You seen a lot of the black communities being affected with regards to this, right? And that's why, a lot of immigration you see primarily is surrounding hoods, Chicago, wherever, primarily black communities. So when you think about this, you think about first those two prongs that you have to renounce your citizenship from the country in which you come from, but you also have to be accepted by the United States.
In response, Professor Keith Whittington argues that the common law rules simply made everyone born in the country a prima facie citizen, subject only to exceptions for children of ambassadors and of foreign armies. A third exception, which he describes as peculiar to the American context, applied to the children of American Indians because the U.S. then included territory under tribal control, despite being within the territorial limits of the U.S. In response to those arguments about the relevance of the complete allegiance to the U.S., Professor Whittington concludes that individuals are subject to the jurisdiction of the U.S. for purposes of the Citizenship Clause, even when they still owe allegiance to their home countries. He rejects the argument that entering the country without permission would defeat an entitlement to birthright citizenship because an illegal alien is not equivalent to an alien enemy subject to the laws of war. No, but they're subject to the laws of nations. They're an illegal invader. Professor Gerard Maglioka further argues that the widespread understanding with roots in English law was that the citizen of nomads would be entitled to birthright citizenship and that those who sought to reject that approach lost the debate in the United States. Professor Maglioka therefore concludes the status of the parents is almost irrelevant to whether a child is entitled to birthright citizenship. So the error in this analysis is he's referring to the roots in English law. But of course, in English law, they were not citizens. In English law, it was not a contractual, mutual agreed to relationship. In English law, you were a subject. The crown had authority over you. It seized that authority on its own initiative. It simply claimed you as a subject and made you responsible for serving the crown. America abandoned that approach through 8 years of Revolutionary War and the achievement of independence. Section 2. These investigations into the antecedent common law are important because the Citizenship Clause relies on a concept, the jurisdiction of the United States, that may have been familiar to the legislatures in the 19th century, but reflects political ideas that are not those of our day. We have long known that the 14th Amendment does not confer birthright citizenship on the children of diplomats, foreign soldiers, or American Indians. These categories show that the status of a child follows that of the parents. But the Citizenship Clause does not reference these categories of parental status. The exclusion results from the application of a broader principle. During the debate in the Senate over the Citizenship Clause, one senator proposed an amendment that would have expressly excluded Indians not taxed. The senators rejected that amendment because the Indians, as part of a separate political community, were not subject to the complete political jurisdiction of the United States. Quote, the very fact that we have treaty relations with them shows that they are not subject to our jurisdiction, said Senator Trumbull. Quote, we cannot make a treaty with ourselves. Trumbull explained that the Indians are not subject to our jurisdiction in the sense of owing allegiance solely to the United States. When another senator objected that Congress had the power at its pleasure to extend the laws of the United States over to the Indians and govern them, Trumbull responded that Congress would have the same power that it has to extend the laws of the United States over Mexico and govern her if it had sufficient physical power to enforce it. He said that we have the power to do it, but it would be a violation of our treaty obligations, a violation of the faith of this nation to extend our laws over these Indian tribes. The debate reflected an understanding that the jurisdiction of the United States referred not simply to the legal authority the United States could exercise over a person, that's regulatory or criminal jurisdiction. It referred to whether the United States would, in fact, exercise its full legal authority, political authority over that person, or would, as a matter of comity or discretion, treat the person as part of a separate polity that had its own legal interest at stake. The question that the executive order implicates is whether that principle extends to aliens illegally or temporarily within the territory of the United States. Has the United States, quote, refrained from exercising its complete municipal political jurisdiction over those aliens? This symposium helpfully engages with that question.
So let's think about all the people that came over here under that immigration parole system, which Donald Trump most recently told those individuals that they would have to go back home. The Haitians, the Cubans, the Venezuelans, the Colombians. I don't know remember if Colombia was in there actually, but the Ukrainians and stuff like that. These people would have to go back home if they decided to have a family over here. And absolutely, when they knew that they had temporary status, well, then their child, in accordance with this, will not have citizenship in this country because they, for one, they had to renounce the allegiance that they have from the country that they come from. And I don't know how they would do that if they were temporary. And also, they will have to be accepted into America. America would have to accept them as a citizen for them to become naturalized. So, and one other aspect that you gotta kind of look at with regards to this is the taxation of the Indians. Does taxation identify you as having some type of citizenship within this country, right? And how would that go about for you to actually say that I have taxation? There's the idea of no taxation without representation. That's something that had to be looked into a little bit further. But I don't believe just because you pay taxes in this country that would ultimately grant you the status of citizenship that you ordinarily would think or that you will want to have in this country. Let's let him continue.
But this debate prompts other questions that deserve attention. First, what is the relationship between owing no allegiance to an alien power and the availability of dual citizenship? Since 1795, Congress has required an application for naturalization to renounce and abjure absolutely and entirely all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty of whom or which the applicant was before a subject or citizen. But the executive branch no longer appears to require new citizens to adhere to that oath. For those born into the citizenship of more than one country, the State Department previously required the citizen on reaching majority to make an election between American citizenship and the citizenship of his parents. And Congress codified the actions by which someone could be deemed to have expatriated himself, given up his American citizenship. But the Supreme Court later held that the State Department could not require a citizen by nativity to elect between dual citizenship upon reaching a majority, and it invalidated the statutory sections providing for involuntary expatriation. One might consider whether the greater availability of dual citizenship affects what it means to be subject to the jurisdiction of the United States, or whether the principle should be understood from the perspective of a Congress that did not expect dual citizenship to be generally available. Second, how does the requirement that birth or naturalization occur in the United States affect aliens detained at the border but released into the country pending a hearing? Courts have held that the Citizenship Clause applies only to those born in the states or in territories destined for statehood, but not in unincorporated territories. The question then arises as to how the Citizenship Clause would apply to the children of an alien who is detained shortly after unlawful entry or who arrived at a port of entry and then is paroled into the country pending a determination of admissibility. Such an alien is legally treated as if stopped at the border, because an alien paroled into the United States pending admissibility has not affected an entry. One might then consider whether the child of such an alien would be born subject to the jurisdiction of the United States. Well, of course not. Third, what is the effect of a statutory enactment of the language of the Citizenship Clause? The First Circuit has said that in construing Section 1401A, which simply is a statutory restatement of the 14th Amendment Birthright Citizenship Clause, the First Circuit has said that in construing 1401A, a court ought to focus on what the unusual phrase subject to the jurisdiction thereof was understood to mean when it became law in 1952, and when Congress first enacted that language in a statute in the Nationality Act of 1940. Well, that's a bad argument, because if you're just repeating the language, the legal language taken from a preceding instrument, document, the soil comes with it. The meaning is the meaning of the original document. There is a basic interpretive problem with that approach. It would be surprising to discover that Congress departed from the constitutional standard by enacting the exact constitutional language. And it would be more surprising still if those congressional enactments, which sought to restrict the possibility of dual nationality, simultaneously liberalized the circumstances under which children of alien parents received American citizenship. But the understanding of subject to the jurisdiction that prevailed in 1940 and 1952 will be of concern to litigants and scholars. The Supreme Court may resolve the legality of Executive Order 14160 before these questions receive the full attention of scholars. The Supreme Court no doubt will have the benefit of the views of able attorneys and many amici curiae, friends of the court, but the detailed consideration of the contributors to this issue provides a solid foundation on which the debate can proceed. All right. So Harvard Law Review did a whole issue just on birthright citizenship.
So, as I was saying, that's Andrew Breaker. He does the Andrew Breaker show. I like watching this show, even though he may at times go a little overboard with the hostility that he has for immigrants that come to this country, to the point to where sometimes I may consider that, he even talks about African Americans. But if you take it from the perspective that he's not talking about black people, he's talking about African Americans. When it comes to the whole idea with regards to who should and who should not be, in this country, if you take a look at it like that and delete the aspects that he's talking about foundational black Americans, then he gives a good analysis with regards to his take on, well, not his take, because he's a lawyer. And what he does, he reviews the cases that pretty much is about right now in front of the Supreme Court. And excuse me with regards to my sounds, because I get tired of my sounds acting up, bro. However, I like to watch him because, like I said, it gives me the opportunity of, looking at reviews, in the legal system. And I think that if you want to actually absolutely be a part of this country, that you need to go into law. Like, you need to go into the system and actually look at and study how the system works. And the only way you're going to actually be able to study how the system works is by looking into some legal cases, looking into some reviews like we just did today, so that you can draw comparisons to, your own lifestyle and how you're living right now, and see if you're living up to the idea with regards to this social contract that we are supposed to have in being United States citizens. Because without that understanding, man, you just, you don't know right from wrong. You don't know left from right. How are you supposed to be living in this country and you don't know the system in which it absolutely supposed to work? And you can be fooled, like this whole issue with regards to birthright citizenship, if you don't go into the law, if you don't go into some of the discussions that are how these laws are being put into place. We get fooled all the time. We get manipulated all the time as we listen to these politicians tell us how things are supposed to work. But if you don't going to these laws, man, you don't have nothing to actually, argue against or, you know, draw back to in the actual interpretation of how things is the actual supposed to work, and when, especially when these laws are affecting you. Tiny Cross-H.U.G on the Trumped Up Live show. Always remember to like, share, subscribe to the channel. Man, this why I like being a soldier. Because I can give stuff like this to you, and I can better as well have the opportunity to improve myself in the transformation of what I ultimately want to become. So it's a good day to be a soldier.